Hi all, welcome to the A-Level Law Essay Practice channel. In today's video, I'll be going through with you a Paper 2 data response question. The question that I'll be covering today is from the examination paper in October-November 2018 Set 3. As this is part 2, sample answer of the video tutorial, I will only share with you the written answer to the question without actually going through with you the structure of the answer itself and how I got to answering it. It is recommended that you actually watch part 1 content guide of this video tutorial first so that you get an idea on how I actually get to answering the question. You may find the link to it in the description below. But if you're confident in answering the question and would only like to know how the answer should be written, then do stick around for this video. Before I begin, please do subscribe to my channel for more video guides and other interesting topics. With that said, let's get started with the video guide for Paper 2 Data Response number 1. Alright, before we start, do note again that this is Paper 2 Data Response October-November 2018 and it's Set 3. So as usual, you should make appropriate reference to the source material supplied for each question. Alright, so now before we actually go on to answer the question, it will be good to first read through the whole question together with the source material and to understand it. So question A. Frank has been a member of parliament for 20 years. He has been reported to the Committee on Standards for sending inappropriate emails to a female colleague. The committee suspends Frank from sitting as an MP for a month. The Speaker gives notice of what has happened to the petition officer who organizes a recall petition. Frank is a very popular MP and out of 100,000 registered voters, less than 5% signed the petition. Explain how the Recall of MPs Act 2015 will apply to Frank. Question B. Anya has been an MP for 10 years when she is convicted of theft. She appeals against a conviction, but before the appeal hearing, the Speaker tells the petition officer in Anya's constituency of a conviction. The petition officer is interviewed on local radio and says he will set up a recall petition at his office the next day. 50% of registered voters signed the petition. Anya's appeal is successful and her conviction is overturned. Explain how the Recall of MPs Act 2015 would apply to Anya. Question C. Carl is an MP who is convicted of making false claims for his travelling expenses. He appeals, but his conviction is upheld 6 months later. The next day, the Speaker informs the petition officer. In an interview on local television on 1st June, the petition officer says that the copies of the petition are available in 9 shops across town and that there is a month in which to sign. On 1st July, 80% of registered voters have signed the petition. Explain how the Recall of MPs Act 2015 would apply to Carl. Right, so that's the end of the question A to C. And yeah, one thing that you should note again is that I'm actually just going through question A, B, and C for this video, and I won't go through question D as it is a full-on essay question. And the purpose of this video is to guide you on how to answer data response question without the question D. Alright, now let's go through the source material. So source material for question 1, Recall of MPs Act 2015. Section 1. How an MP becomes subject to a recall process. Sub 1. An MP becomes subject to a recall process if Sub A. The first, second, or third recall condition has been met in relation to the MP. Sub B. The Speaker gives notice of that fact under Section 5. Sub 2. In the Act, recall petition means petition calling, Sub A, for an MP to lose his or her seat in the House of Commons. Sub B, for a by-election to be held to decide who should be the MP for the constituency in question. Sub C, the first recall condition is that, sub A, the MP has, after becoming an MP, been convicted in the United Kingdom of an offence and sentenced or ordered to be imprisoned or detained, and sub B, the appeal period expires without conviction, sentence or order having been overturned on appeal. Sub 4. The second recall condition is that following on from a report from the Committee on Standards in relation to the MP, the House of Commons orders the suspension of the MP from service of the House for a specified period of a requisite length. Sub 5. A specified period is of a requisite length for the purposes of subsection 4 if subsection sub A, where the period is expressed as a number of sitting days, the period specified is of at least 10 sitting days, or sub B, in any other case, the period specified, however expressed, is a period of at least 14 days. Sub 9. The third recall condition is that, sub A, the MP has, after becoming an MP, been convicted of an offence under section 10 of the Parliamentary Standards Act 2009, which is an offence of providing false or misleading information for allowances claims, and sub B, the appeal period expires without the conviction having been overturned on appeal. Alright, so firstly, this whole thing is under section 1 of the recall of MPs Act 2015, and generally it is about the situation or the definition of recall petition and the requirements, and also what will become of the recall petition, and also the conditions, which is the first condition, second condition, and the third condition. So the first condition generally concerns with the, what do you call that, conviction. Yes, conviction of an offense and sentence or order to be imprisoned, all this. The second condition concerns with suspension. Alright, suspension for a specific period of time, and also in sub 5 it actually did emphasize or did go into further detail regarding what does it mean by of the requisite length for the purposes of subsection 4. Then the third condition is concerning the offense of providing false or misleading information for allowances claims. Alright, so now that we've understood that, so let's go to the next part. Right, section 5, speakers notice that first, second, or third recall condition has been met. Sub 1, as soon as reasonably practicable after becoming aware that the first, second, or third recall condition has been met in relation to an MP, the speaker must give notice of that fact to the petition officer for the MP's constituency. So here is about after section 1 has been satisfied, meaning either one of the three condition has been met, then the speaker under section 5 should, as soon as reasonably practicable, give notice of that fact to the MP, to the petition officer for the MP's constituency. Alright. Okay, next. Section 7. Where and from when the recall petition may be signed. Sub 1. Where the petition officer for constituency receives a speaker's notice, the officer must, as soon as reasonably practicable, designate sub A, a place or places at which a recall petition is to be made available for signing, and sub B, a day from which the petition is to be made available for signing. Then sub 2, a maximum of 10 places may be designated under subsection 1 sub A. So here subsection 7 is with regards to where and from when the recall petition may be signed. And generally the officer must, as soon as reasonably practicable, designate a place or places for which it is made available for signing, and also the day which is made available for signing, and also that a maximum of 10 places may be designated for signing, not more than that. Right, next, subsection 14, determination of whether recall petition successful. Sub 3, for the purposes of this Act, a recall petition is successful if the number of persons who validly sign the petition is at least 10% of the number of eligible registered electors. Right, now that we have already gone through the question as well as the source material, we should be able to answer the question. As this is part 2 of the video guide, I will straight go into the answer itself without actually explaining how I get to the answer. But if you are more interested to find out how I actually answer the question or how to answer the question, you should check out the first part of this video. You can actually look for it in the description below. There's a link down there. But if you are confident in answering the question and would like to straight go into the answer itself, then stick around and I will show you my answer to these questions. Alright, so let's get started. Right, so for question A, as a member of parliament, Frank may be subjected to a recall petition to remove him from that public position, even though he has been serving for the last 20 years since he has been reported to the Committee of Standards for sending inappropriate emails to a female colleague. However, to determine if the recall petition is successful or not, the Recall MPs Act 2015 will be utilized and applied to Frank's situation. Under Section 1 sub 1 of the Act, an MP becomes subject to a recall petition if the conditions under Section 1 sub 1 sub A and sub B has been met, meaning that the first, second or third condition has been met in relation to the MP, and that the Speaker gives notice of that fact under Section 5. So, based on the facts, these conditions have definitely been satisfied since the Committee of Standards, under the second recall condition and upon the Speaker's notice, have suspended Frank for a month as per Section 1 sub 4, which requires that the House of Commons order the suspension of the MP from the service of the House for a specified period of the requisite length following a report from the committee. And on top of that, following Section 1 sub 5 sub B, Frank's suspension was for a month and so meets the condition of specified period of a requisite length of at least 14 days. However, even though Frank's situation might meet the conditions above for possible recall petition under Section 1, Section 14 states that a recall petition will be successful if the number of persons who validly sign the petition is at least 10% of the number of eligible registered electors. And lastly, applying this to the facts, it would seem that Frank is a very popular MP, and out of 100,000 registered voters, less than 5% signed the petition. Therefore, it is very likely that Frank will remain as an MP, disregarding what has initially transpired. So this is basically the answer for sub-question A, and as you can see, I started off by actually introducing the situation in the question, and also there's a bit of a thesis statement here, a very quick one. And for all A, B, and C, I've actually also, later you will see that I've actually also put down section 1 sub 1, A, B, and also section 5, right? Because this is basically the main requirements to see whether or not the 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 MP can actually be removed from Parliament. So after that, then of course I go straight into giving the relevant sections, which is here section 1 sub 4 concerning suspension, right? And also 1 sub 5 sub B concerning the condition of specified period or requisite length, and also section 14 regarding the petition itself, and lastly also applying everything into the facts, right? And then finally getting into the conclusion itself. So as you can see, the conclusion is usually at the end and not in the beginning. Alright, so this is for question A. Right, now for question B. So question B concerns Anya. Alright. Alright, now next. As a member of Parliament, Anya may be subjected to a recall petition to remove her from public position, even though she has been serving for at least 10 years since she is convicted of theft. However, to determine if the recall petition is successful or not, the Recall of MPs Act 2015 will be utilized and applied in Anya's situation. Under Section 1 sub 1 of the Act, an MP becomes subject to a recall petition if the conditions under Section 1 sub 1A and B has been met, meaning that the first, second, or third recall condition has been met in relation to the MP, and that the Speaker gives notice of the fact under Section 5. Alright, so based on the facts, it would seem that she has potential to be covered by Section 1 sub 3, as she is an MP who has been convicted in the United Kingdom of an offence of theft, and so the first recall condition may be satisfied. However, because she was in the process of appealing the conviction and that her appeal is presumably not expired yet as per Section 1 sub 3 sub B, the Speaker's notice to the petition officer in Anya's constituency is deemed invalid. This is because Section 5 sub 1 requires that the first, second, or third recall condition must have been met in relation to an MP before notice is given to the petition officer for the MP's constituency, and this has clearly not been met because before the Speaker gave notice to the petition officer. Additionally, even though the petition officer has set up a place for people to pen their signature in the petition as per Section 7 sub 1 sub A and B, which states that a place and time for the signing be available, this effort will be invalidated by the fact that Anya's appeal is successful and her conviction is overturned. This is disregarding the fact that the condition under Section 14 has been met, whereby the signature in the petition has exceeded that required by 40%. Okay, so here you probably noticed already that the first two so-called paragraphs here are actually copy-paste from question A. It doesn't really matter. I just change some of the details here, especially this one here. Right? It doesn't really matter if it's the same or more or less the same, because in this situation, there's no difference between A, B, and C with regards to the introduction itself, other than the facts, the details. So here, the difference starts from here based on the fact. When you apply to the fact, it will be a little bit different already. And here, the first one is with regard to Section 1 sub 3 concerning how she's convicted. And then next is 1 sub 3 sub B concerning her appeal. and also the speaker's notice, which is actually invalid, considered as invalid. And then section 5 sub 1, this is regarding what the speaker has said, right here, this one here. And additionally, the last part is regarding section 7 sub 1 sub A and B, concerning the place and time available for signing. And finally, section 14, concerning the number of signatures. But disregarding this thing, she still will remain as an MP because, well, her, what do you call that, yeah, here, the fact that Anya's appeal is successful and a conviction is overturned. So even though you know that from the beginning itself it says that her conviction is overturned, so therefore nothing should happen to her, but in order to answer the question properly, you need to go through the whole working. You need to go through all these things. Otherwise, you won't be able to get the marks that you deserve. Right, next one, question C. Right, so this concerns Carl. Right, Carl. So as a member of parliament, Carl may be subjected to a recall petition to remove him from the public position as he is convicted of making false claims for his travelling expenses. However, to determine if the recall petition is successful or not, the recall of MPs Act 2015 will be utilized and applied to Anya's situation. Under Section 1 sub 1 of the Act, an MP becomes subject to a recall petition if the conditions under Section 1 sub 1 sub A and B has been met, meaning that the first, second, or third recall condition has been met in relation to the MP, and that the speaker gives notice of the fact under section 5. Next, based on the facts, because Carl has been convicted of said offence and that after 6 months of appealing, his conviction was still upheld, the third recall condition has been satisfied under section 1 sub 9 sub A and B. So in subsection A, it covers the offence of providing false or misleading information for allowances claim, which an offence under section 10 of the Parliamentary Standards Act 2009, and subsection B states that his appeal period must have expired without the conviction being overturned on appeal. Next, the speaker has done the right thing by waiting for the appeal to be unsuccessful before giving notice to the petition officer concerning Carl's conviction. Therefore, according to section 5 sub 1, the speaker has effectively given notice of that fact to the petition officer for the MP's constituency when he did so the day after Carl's appeal failed. Additionally, to ensure the validity of the recall petition, the petition officer has set up places and days for people to pen their signature in the petition according to section 7 sub 1 and 2, where it states that places and days for signing must be made available and that a maximum of 10 places is allowed for this activity, which the petition officer has followed since only 9 shops were made available for signing across 2 to 1 month's time. So across town, typo there. Sorry, there's a typo there. Yeah. Okay. Next, with 80% of registered voters having signed the petition by the end of the 1 month period, Section 14 is satisfied as more than 10% of the number of eligible registered electors have penned their signature in the recall petition. Therefore, Carl has to step down as an MP and allow a fresh by-election to take place. Okay, so same thing. Here is standard. So from here onwards, right? Firstly, section 1 sub 9 sub B concerning false or misleading information for allowances claims, and also section 10 of the Parliamentary Standards Act 2009, and also subsection B of section 1 subsection 9, right, concerning the appeal, right? Then next is concerning the speaker under section 5 sub 1, and here of course the notice was only given after. Alright, so he was waiting for the appeal to become unsuccessful first. Alright, then next section sounds out 1 and 2 concerning places and days for signing. One of the things that you should also highlight is concerning the maximum of 10 places, because only 9 shops were made available, and also the fact that 1 month's time was given. And then lastly, section 14 concerning more than 10%, right? And because there's 80% of them who voted that person out, so definitely Carl has to step down, right? So this is basically how you answer the question. And yeah, one more thing is that lastly to notice is that the word count for each answer. So the first one is 31 words. Question B, 231 words. Sorry, 331. The other one is also 332. Then question C, 388. So the average, I would say the average word count for each answer should be around 350 to 400 words maybe, or 300 to 350 or to 400 words, around there. And usually it take around more than half a page to 1 page, or a little bit more than that in your examination paper. Alright, so this is for you to gauge yourself, so that you know or can figure out whether or not you have written enough for your answer. That's all for part 2 sample answer of this video tutorial. For a full working of these questions, please do check out part 1 content guide of this video tutorial. You may find it in the description below. If you like what I have done here for you, please do support my channel by subscribing to it, liking it and sharing it with your friends, as it doesn't just help my channel to grow, but it also helps those who need some guidance. Thank you for watching, and I'll see you again next time.